And a very good evening to you, and welcome to today's edition of Politics 101. Very uh, beautiful uh, afternoon where I am, and I am certain um, it's evening time in Guyana and on the east coast of the United States of America, much later in the night in Europe, those of you who are joining us from Europe, and of course in our wider Caribbean, the same time zone as in Guyana, 6:30 in the evening. Um, I rather suspected the same in Suriname, French Guyana, Brazil, Venezuela, where we have um, some Guyanese. Um, we have, of course, lots more Guyanese in Suriname and French Guyana. Some of you do join us, and I want to welcome you if you're joining us from Suriname and French Guyana. As we say in the old days, we used to say Paramaribo and Cayenne, the capital cities of those countries. Um, Please, as you join us, please alert others that we are on. Share the link. It's very important that you do so. I have been advised that we depend on you to share the link to your friends, to your contacts, so that that multiplies the audience, or remind the people that we are on. Tonight, of course, we are going to be tackling one of the difficult but pertinent subjects, and that is the court, the courts, the courts. Um, it's not what you all will call a sexy subject. It's not part of the red meat of accusation and counter accusation. But as I've said on this program over and over again, our objective here is not just to get you worked up, but also to bring you the kind of information, the kind of analysis that you would need as tools in your hand as we engage the struggle for equality, for justice, and some will go as far as to say for liberation in Guyana. We take the view on this program, of course, that the struggle goes on, that freedom is not a moment, freedom is a process, and it's a process that would encounter obstacles. We will encounter obstacles along the way. Someday we're up, someday we're down. Someday we're up against it. Some days we could see some light along the way. Some days we may not see any light, but we have to engage the struggle, and we have to be mindful that our task, of course, is to help to clear the way so that we can see through. Getting a feedback there, but I suppose they will fix that. And so we want to we we want to we want to engage the subject tonight of the court. Now, as you know, there are three branches of government, three branches of all government. The legislative branch, what we call the Parliament, the National Assembly, and that is the branch that makes the laws. The executive branch, the branch that carries out the laws, and the judicial branch that mediates. The judicial branch has the task of adjudication, deciding whether laws are in keeping with the Constitution, deciding whether citizens' rights have been violated, deciding whether the other two branches, may have overreached. So it's a very important branch, and the understanding in our system of government is that these branches are co-equal branches. But there's also the understanding that they also have separate spheres of operation. They are co-equal, and that each of them has its own task. As I said, one is to make the law, one is to carry out the laws, one is to adjudicate the law, to serve as the umpire, to serve as the referee. There are also checks and balances, although this is not explicit in our Westminster system. There's also the checks and balances that each branch serves as a check on the other branches. And given the task of the judicial branch, the courts, that branch is perhaps more charged with the task of checks and balances in the system. And so, therefore, each branch is as important as the other branch. Given the way in which our Westminster system has emerged in the Caribbean, we tend to operate with the executive being, if you will, more equal than the other two in the sense that being charged with carrying out the functions of day-to-day governance, that the executive branch has assumed more power than the other two branches. Some would argue that what we have in our system is executive tyranny. Some may argue that what we have is executive supremacy. It is what Anthony Payne and Paul Sutton, they refer to our Westminster system, which we were left by the British, as adopted Westminster. Because in many regards, the British Westminster system has moved away from its original moorings, and our adopted Westminster system has not had very much change since the time of independence. So we want to talk this evening about the role of the courts, and we want to talk about it within the context of our present. The courts played a very prominent role during the last election. That was quite abnormal for Guyana. The courts have tended to stay very far away, partly because we have not always used a device that is called judicial review. Judicial review is a function of the court to review decisions by the other two branches, to review decisions by the parliament and decisions by the executive. Judicial review. I'm not too sure about its European roots, but in the United States, judicial review came about in the early decades of US, the founding of the United States of America. And it's not enshrined in the American Constitution. Judicial review is not enshrined in the American Constitution. Judicial review arose out of a case, Marbury versus Madison, in which the court took upon itself the task of reviewing the other two branches. In a sense, what Marbury versus Madison did was to expand the role of the courts, because the framers of the American Constitution left it to the Congress to create the courts. And the Congress duly passed the Administrative and Justice Act, which created the courts. But then when this case, Madison versus Madison, went before the court, asking the court to find that the president had not carried out one of its functions, the question before the court is whether the court had the jurisdiction to hear the case. And the court said, yes, we did. And they went on to hear the case. And so took it upon themselves, this function of reviewing, because the court was asked, can you tell the president? The president was saying, given separation of powers, another branch of government cannot tell me what to do, cannot tell me how to carry out my powers. And the court said, no, we take that power unto ourselves. Now, our Guyana, judicial review was used a lot during the elections. In fact, at the end of the day, some people who have little regard for history, present history, accuse the now opposition of overusing the court. But as I remember, in the first side in the election to go to the court, this is after March 2nd, the first side to go to court was the PPP. And once one side goes to court, the other side will go. And so we had this list of cases in which the court was asked to make some adjudication. And in many regards, the court had to engage with some novel issues that it didn't have to deal with before. Before, when it came to election, our court dealt with elections petition after an election. But now our court was asked to deal with issues before the elections was adjudicated. And it is my humble layman's opinion that the court would have played a very important role in the outcome of the elections, much like in 2000s in the United States of America, Bush versus Gore. Similar situation in which the court got involved while an election was not settled. And in the end, it was the court that had the final say, much like our election in 2020. And many Americans would swear that that election in 2020, that the George Bush was installed as president as a result of the court, a majority of 5-4. In political science, we said that it was one justice that determined that election. So there is a strong view in Guyana that our election in 2020, the court played an important role. Some would say that it was the court that made that final decision. Because by the end of the process, we had two results in that election. One result based on votes in the boxes, and another result based on the method by which the votes went into the box. One was a raw count and one was an audited count. And the court made the decision that they will declare a winner based on the raw count. In effect, the court was ignoring the process by which votes got into a box. In fact, it said, let that audited count be used in an election petition. So the court cannot feign ignorance of the audited count. It is saying that the law says that you hear it at the petition. So the court was actively involved. Now, when a court becomes actively involved in an election, the court, understandably, would be seen by the larger population in political terms. Now, the objective is this. If you're an umpire, you're expected to be neutral. But given the way in which the court was involved in those elections, understandably, it was seen in partisan terms by the supporters of those who ended up being adjudicated as the winner, and also, or more so, by the supporters of those who were adjudicated to be the losers. So one would not be surprised that large sections of the opposition constituency appears to have lost confidence in the courts as an important tool of justice, an important medium of justice. And that raises important questions, because when half of your population loses confidence in an important institution, such as the courts, you are playing with trouble. And because if one side sees the courts as hostile to its interests, by definition, the other side will see the court as friendly to its interests. And so the court, in spite of itself, is now drawn in to the political contestation. That is not a nice position for the courts of a country to be in, where half of your population views the court in hostile terms, and the other side views the court in friendly terms. Now, my position is that we ought not to view the court in hostile or friendly terms. We need to view the court as a legitimate institution that is neither hostile nor friendly to the interests of any group. And of course, the opposition in the last 2 years has been trying to figure out how to deal with the present political situation, which has changed dramatically with the introduction of external forces, the introduction of oil. Our politics have become much more complex. And understandably, the opposition was not prepared for that complexity. And so it's been trying to find its way. But don't say that to the supporters, because the supporters are not sympathetic to an opposition finding its way or trying to find its way. And so some of the opposition supporters have been saying that the opposition has not been using the courts enough. I rather suspect that some people have been saying both, that the court is a waste of time, but the opposition is not using the court. We tend to be a little contradictory. We tend to be a little contrary. We tend to, as Professor Forde used to say, we are a people of order in chaos and chaos in order. When people say, I grew up as a little boy, people say, black man contrary. We tend to be complex. And we have to be, because we are a complex people given that complex history that we have come out of. So, look, tonight we want to talk about the courts and the role of the courts in the struggle for social justice. Because from the Middle Passage to the present, we have had to engage all institutions in our society in that long struggle through slavery, colonialism, indentureship, post-colonialism. We have been forced to engage all institutions, including the courts. Thurgood Marshall, the venerable United States Justice who became the first Black member of the Supreme Court in 1967, I think. He talked about a living constitution and therefore the court having that important role of an activist in search of justice. And he was speaking as an African American, as a Black person, that he saw his role on the court as partly as advancing justice. And so therefore, you advance justice while keeping the integrity of the court. One would say that was the challenge for a Thurgood Marshall. Is the Thurgood Marshall theory, is understanding of the praxis of the court, is that relevant to our Caribbean? Is that relevant to our Caribbean? The court must decide whether a man who's accused of committing murder, whether he's guilty or not guilty. The court must make decisions based on individual conflict in our society. The court must also make decisions on collective conflict in our society. So the role of the court is as complex as our society is complex. We want to talk tonight about this, the role of the court in our struggle for social justice. We have a number of cases before the court. We have the petition, we have the recent Natural Resource Fund case that has been filed. We have, we understand the opposition is threatening to file a case objecting to the manner in which the acting commissioner was installed, sorry. We have cases before the court, the Henry cases. We have this case with Shawnette Bollers. There are a number of cases that before the court, the commissioners just said that they did an investigation of the Shawnette Bollers case and the file is now with the DPP. We have some challenges to our practice. Recently, the head of the Guyana Bar Association said that the method that is used to appoint our Chief Justice and our Chancellor is flawed. It doesn't work. She is suggesting that we need a new system. Is she on track? That is something we want to talk about. That is something we want to talk about. There was also the suggestion that the Director of Public Prosecutions, the DPP, has too much power. We want to talk about that. So we're going to spend the first part of our discussion with our two guests tonight, who are two attorneys at law, who have been involved in the cases before the court, who are very knowledgeable of the process between March and August in 2006, a defining moment in our history, not for the reasons that some people think it was defining, but for some other really fundamental reasons they were involved. And so we're going to have them. I'm talking about attorney at law, Mr. Roysdale Forde, who's the shadow Minister of Legal Affairs in the National Assembly, and also a member of the People's National Congress, Mr. Mayo Robertson, who was the lead lawyer in that Yolita Anthony case that challenged the constitutionality of the recount order. He's on, and he's been on this program before. Both of them have been on this program before. They're going to bring their expertise and their experience to bear on our discussion tonight. Tell you what, I'll take a short break, and I think we're coming down to the end of that election. So today may be the last day we'll play that advertisement. I'm urging people to make the right decision in the election for the leadership of the Guyana Teachers Union while the operator is getting that ready. Want to remind you, want to apologize that last night we got kicked off of Facebook for some minor infraction. And so you couldn't follow the program, very powerful program on Henry Rodney last night. We are going to broadcast that program tomorrow night. So we're going to have an extra, there you go. Join us tomorrow night for the special broadcast of the tribute to Henry Rodney, which we did last night, and you couldn't get us on Facebook because Facebook thought we played a little piece of music without doing the necessary disclaimers. And so while we were broadcasting on YouTube, we didn't get to broadcast on Facebook. So tomorrow night, you're going to be able to see that program as if it were live tomorrow night at 6 o'clock. Take a short break. And when we come back, attorneys at law, Mayo Robertson and Roysdale Forde.
It is time for change in the Guyana Teachers Union, and two candidates, Vanessa Kissoon and Coretta McDonald, are running for President and General Secretary respectively. Listen, as they tell us why teachers across the country should vote for them in the election.
You're running for President of the Guyana Teachers Union. Why are you running?
I believe that it is time that the Guyana Teachers Union and teachers get the type of representation that they deserve. I believe that it is time that teachers be respected. And I honestly believe, Dr. Hines, that I am the person to take the Guyana Teachers Union and the teachers of this beloved country forward and into the future.
What have you learned about your stint as General Secretary that makes you want to continue?
Coretta McDonald is a part of a team, and I like, and I've been promoting team. The fact that you're asking me this question about what I've learned, I have learned to be even more resolute against this regime. I've learned that. I want to say to teachers, on that ballot paper, you're going to see the various positions. So you'll have president, you have two names there. Look for Vanessa Kissoon, put your X right there. For first vice president, you're going to see two names. Look for Lesmin Collins, put your tick there. For second vice president, you're going to see two names. Put your tick to one of those two names. Then you're going to see the position of General Secretary. You know where you have to put that, Coretta McDonald.
Vote Vanessa Kissoon for President of the Guyana Teachers Union and Coretta McDonald for General Secretary.
And welcome back to Politics 101. Our Thursday evening edition. Welcome back to all of you. Sorry we missed you last night because of that hiccup. Our sincere apologies. But join us tomorrow night for that special edition, The Life and Times of Henry Rodney. Let's bring in our guests for the interview tonight. Mayo Robertson, attorney at law, and Roysdale Forde, also an attorney at law. Gentlemen, good night and welcome to Politics 101. I hope that my layman's introduction about the courts do not deviate from your expert understanding of the role of the court. But let me ask you that broad question that I was attempting to introduce. Why is the court an important and integral institution in any society, but especially in a country like Guyana, where conflict is perhaps more rife than other societies in the post-colonial world or wider Caribbean, Africa, and so on? Why is the court important and integral? I'll start with you.
Okay. Well, David, I think you sort of hit it on the head when you said the courts perform the role of an umpire, and the umpire is supposed to be a neutral person who looks at the game, and when one person doesn't follow the rules, he signals to that person, you didn't follow the rules, and we penalize you, and if you keep on breaking the rules, the penalties can get more severe. That is an accurate description of what the court does. And if I may be permitted to quote from one of the justices now in the CCJ, Justice Jamadar, he described the court as the guardian of the Constitution. And the court, and that also is a very apt description. It gives us a sense of the role that the court has to play in our system of government, the three separate branches. The court looks around to make sure that everybody is playing according to the rules. The court is the institution that is equipped by training and experience to decide whether the Constitution is being followed. And since we are a society based on a constitution, the role of the court is perhaps more impactful in the day-to-day lives of members of the society than the other two branches, in the sense that the court has to make sure that those branches are all following the Constitution.
Okay, you're finished there.
Yes.
Mayo, thank you. Let's bring in Roysdale. Roysdale, you want to tackle the same question? We're not hearing you.
Hi, good evening, Dr. Hines. Good evening, Mayo. Good evening to your listeners. I believe both of you have captured the essence of the court, both at a macro and a micro level, which is basically to be the center, the organ that will be able to deal with conflict resolution. The reason why I put it at the macro-micro level, at the interpersonal level, to resolve disputes between or among individuals, and at the national level to ensure that there's compliance with the ground norm, the basic standard of governance in the Constitution, which is usually documented and expressed in a Constitution. So the court is to enforce compliance with the Constitution, to ensure that rights are complied with, to ensure that organs and institutions established by the Constitution stay within the powers and confines of power and authority conferred on them. So I believe that the court plays a very fundamental role, not only in the Guyanese society, but in any society that attempts to advance themselves as a society based on rules and laws and not on a society based on men.
Not on a society based on men. And as I intimated during my introduction, that from time to time in any society, sections of the population could begin to lose confidence in the courts. That introduces not a very nice situation. And I was kind of projecting that there may have been some erosion in certainly the constituency of the opposition erosion of confidence in our court, especially at the top part of the top tier of our court, and one may say at one of the bottom tiers too. Given the role of the court in the elections, first of all, let me ask you to do this. Was it unusual? Was it unusual, or is it unusual for a court to have been so active in an electoral process before the results of an election was determined? Was that a first for us? And are there instances of that around the world that you may have noticed? Mayo, start with you.
Okay. Actually, I think Roysdale is probably much better equipped to answer that question than I am, but it's not uncommon. It was certainly a first for us here in Guyana, because as you mentioned earlier, David, typically disputes concerning the election are resolved by election petition after a result is declared and a government goes into power, and you have a limited time within which to resolve those petitions. It is not unheard of, though. And while we were litigating these issues, Roysdale was able to come up with a number of cases from all around the world where there have been instances of challenges before the result is declared and before the government has been sworn in. But it is far less common than the practice of challenging the results through a petition after the election. And the reason is very simple. It tends to avoid chaos. You don't want to have, under normal circumstances, an extended period of time in which people don't know which government they elect. They can't identify the entity or the party that they elected to run the country. So a good practice, I would suggest, is that as far as possible, that these issues be resolved very quickly and by way of post-election litigation. With an important caveat, though. As you were saying, the courts are the guardian of the Constitution. And if the elections are conducted in a wholly unconstitutional manner, then I think it is fit and proper for an approach to be made to the court before the election results are declared, because we have to let the court decide whether or not the election was a sham or whether the election was held in a good faith way, following all the rules, but some things went wrong. And that, I think, is where we were following the elections in March of 2020.
Roysdale, come on in and deal with the question. I think Roysdale is making his way in. You know, we have these bandwidth problems here and there. But Mayo, you raised that very important question, and I can't emphasize it more, that indeed the court has this dual function, as you said there, of ensuring that if there are problems with the election, and the election petition should establish that is settled law. But the court has the overarching function of ensuring that the Constitution is followed. And I think it is that collision, as you quite rightly said there, that led to what we saw for 5 months, a delay in the outcome of the elections. While we're waiting on Roysdale to come in, Mayo, if you can bring us up to date on where the petitions are.
Well, there are 2 petitions. One of them is on its way to the CCJ. And I say that because in that particular case, the Chief Justice had ruled that the petition should not proceed because she believed a necessary party former President Granger, was not served within the time required by law. She did not believe the evidence that was provided that service was complied with and the law was complied with. And once she made that decision, an appeal was filed to the Court of Appeal, and the lawyers for the government took the position that the Court of Appeal did not have jurisdiction to hear the appeal from the Chief Justice's ruling that the petition could not proceed. The Court of Appeal agreed with us, and that is, they agreed that they had jurisdiction to hear the appeal. But before the hearing of the appeal could proceed, the representatives of the PPP and the government sought leave from the Court of Appeal to take the matter to the CCJ on that very question as to whether the Court of Appeal had jurisdiction. So we're still at the point where the question of whether the Court of Appeal could hear our appeal is being decided. The CCJ is going to decide if they have jurisdiction. And if the CCJ decides, yes, the court has jurisdiction, then it goes back to the Court of Appeal, and then we make our arguments showing why we believe the Chief Justice fell into error when she ruled that the petition could not proceed. That is the status of the of one of the petitions.
So therefore, the second petition, go ahead. You go ahead.
Yes, the other petition was heard before the Chief Justice. And in that second petition, the issues were a lot narrower. That second petition, or it was actually first in time, but the other petition, I should say, was focused essentially on strictly legal arguments as to whether the recount that resulted in a declaration was lawful at all. And several arguments were advanced. I believe persuasive arguments were advanced. The Chief Justice did not agree with those arguments. And so she made a decision that petition should fail. And that decision is also being appealed at the Court of Appeal level. But there has been no challenge to whether the Court of Appeal could hear the appeal on that other petition. So that is, in a nutshell, that is where things stand with those two. With respect to the one that is going to be heard by the Court of Appeal, I guess it's just a question of scheduling. The court will eventually notify the parties as to when briefs have to be prepared, when arguments are going to be heard, and we await that notification from the Court of Appeal.
It's interesting that you said that the government side challenged, made a challenge as to whether the Court of Appeal could hear the appeal of the first one, but they didn't challenge the second one. And there's similar cases, or they're different?
They're different in the sense that with the petition that they're challenging, the petition in which they're challenging the jurisdiction of the Court of Appeal, the Chief Justice did not really hear any arguments about the substance of the case. She made a decision that it could not go forward because, in her opinion, a necessary party was not served within the time required by the law, and she made that decision. So in that sense, they're different. In the other petition, legal arguments were made. Legal arguments were presented to the court, and she heard both sides and made a ruling. In the case of the petition where the jurisdiction of the Court of Appeal is being disputed, facts were going to be far more important. That petition is founded more on the facts and circumstances that gave rise to the belief among many people that there were tremendous irregularities. The other petition where the jurisdiction of the Court of Appeal is not being challenged is based strictly on an interpretation of our law and the Constitution about the recount process. So that's where they differ.
That's where it is. As we would say in Guyana, the first one, the one that is on its way to the CCJ, could be interpreted as having more teeth than than the other one. Now, as a lawyer, you wouldn't want to say that, and so that is why I couch it in layman terms, because I think they're equally important cases. If you look at it in the larger scheme of things, but those of us who do politics day to day would want to say, if the PPP is more interested in stopping one, Hinterbeniba met Washiba notice. Roysdale is back. Let's backtrack, Roysdale, and let's talk about the question that you were about to respond to when you got thrown off. That is the court and its role during the 5-month period.
Thank you again for allowing me to respond. I believe that the role of the court during that period is a very interesting and important one. And you know, Dr. Hines, very early in your show, I was listening to your introduction, in which you pointed out in a very practical way that it was not the APNU AFC coalition that first started these court proceedings. It was actually the PPP that first instituted the proceedings. And what happened after resulted in really and truly a court-driven, a judiciary-driven electoral process that even dealt with the terms and conditions under which these elections results would have been declared. Whilst it would have been quite unusual for Guyana, there would have been repeated instances, well-established cases, as Mayo would have pointed out, when this would have happened. I believe that the role of the court may be considered in some points of view as being very disturbing, but I believe that the role of the court, without getting into the very nature of the decisions and what the court decided, I believe it indicates a very progressive development. There would have been numerous instances in the past, in terms of our local elections, when all sorts of allegations would have been made in relation to the outcome of elections. And I believe that there would be cases which the court will have to determine prior to the declaration of the result of an election. In this case, in this matter, in the context of what happened here, I believe the first decision by the court really and truly caused the entire electoral process to go out of sync, right down to the point where the Guyana Elections Commission itself decided that they were going to utilize a certain process as outlined in Order 60, but decided that they were not going to utilize that process. We had instances where the issue of the involvement of CARICOM and the remit of CARICOM within the entire process leads one to come to some serious conclusions, which is not necessarily always favorable in terms of the operation of the courts. But I believe, Dr. Hines, the fundamental point that we're making this evening, and the point that you started on, is that the court remains a fundamental institution in our society. And despite we may engage the institution, we may not get what we want from it. I don't believe that is the sort of institution that we could blank. It's not the sort of institution that we could put to the side and then simply say to ourselves, we're not dealing with the courts. I would believe that such an approach will be inimical to the interests of the APNU AFC coalition, its supporters, and to the country at large.
Thank you. Mayo made the point. I want to dwell on that point that you made because it's something that I have been saying to myself and I've been attempting to say it publicly, but it's very difficult to get people to listen to it. Your point that that first decision by the court opened the way for all kinds of things. First of all, the delay for 5 months. And then the kind of spiraling that went on after then. Mayo made the observation that, look, elections petition, the law, settled law, is that you decide if there are discrepancies of during an election, you take it to an elections petition. That's settled law. But he also pointed to the overarching function of the court of ensuring that even something like an election or including something as important as an election should be conducted within the confines of the Constitution. That is, that the court, even before a decision, could intervene to ensure that the conduct of the elections are in line with the Constitution. Are those two things in tension with each other, or there is a way in which they converge?
I believe that they're not necessarily in tension with each other, but a layperson may want to feel that they're in tension. But for example, Dr. Hanks, let us look at this. For example, we brought before the court the issue of GCOM's involvement with CARICOM and the role of CARICOM in that communique, I believe it was. I may not be using the right term to describe the document that was entered into between CARICOM and GCOM and so on. Because that was a fundamental issue of GCOM's exercise of its constitutional authority as the sole organ under the Constitution to run, manage, and determine our elections results. And basically what that meant, if it was allowed to give effect to it and its operation, GCOM was largely outsourcing, relinquishing, or probably to use the better word, abdicating some proportion of its overall responsibility under the Constitution to deliver an election result or election process. So that was an instance in which the court, in my mind, quite frankly and properly intervened to ensure that the organs under the Constitution act in accordance with the Constitution to do what they had to do. That is completely different from the sort of case that unleashed the judicial-driven electoral process that we had in 2020. The first case was an allegation that the returning officer was not counting it in a manner in which it was supposed to be counted. Now, you would see, Dr. Hanks, that there's no way in our Constitution that gets into that sort of issues in a Constitution. And therefore, those sort of matters are dealt with by ordinary law, by statutory law. And the traditional orthodox views in relation to electoral matters and laws governing them is that that sort of issue is the issue that would have been proper for an election petition because it did not arise or touch on the execution directly in relation to the exercise of any constitutional authority of GCOM, but more in terms of its execution of its authority rather than the abdication of its authority. It may sound as if I'm cutting fine pieces of paper, but these are important distinctions which underpin the exercise of this important jurisdiction. On one hand, to ensure that the Constitution is complied with, on the other hand, still to allow whatever complaints that may arise during the electoral process to be dealt with at the level of the election petition post the declarations.
And I have no problem with you cutting pieces of paper. You know, and it's one of the reasons that I do this program. I'm a teacher by profession, and I believe that there's a role for public education. And I would be glad if, for example, young reporters, especially in the media, would be listening to a program like this, looking at a program like this. Because often I look at the reporting on those 5 months and they're driven by what politicians say rather than an understanding of intricacies. Whether you support one party or the other, that's not my business. But you ought to understand the intricacies that period introduce us to. Mayo, let me bring you in here. Because I know I wasn't crazy when it came to that conclusion that first case, I don't know if it was the Hyder case or I can't remember the name to it, but that first case opened a can of worms. And I think the court may have made a misstep in that first case there. For example, where does the latitude of GCOM stop and the Constitution begins? You know, I think that's a serious. Go ahead, Mayo.
Yeah. The very first case, as Roysdale said, which was brought by the PPP, challenged the type of thing that we normally have challenged by election petition. They were challenging the way the votes were counted, and that is quintessentially the type of thing that happens after an election petition. But the court pronounced that it had the right and the authority to adjudicate upon that. And because of that, we ended up with this so-called agreement for a recount, the agreement between the heads of the political parties and CARICOM. And that resulted in GCOM abdicating its constitutional function because GCOM could not tell CARICOM, you supervise the recount. And that is why we took the case to court. And the courts agreed with us that, look, CARICOM should not be involved in this part of the process. That is solely GCOM's responsibility. So CARICOM, you have to leave. And that was important. And like you said, it is an important civics lesson for all of us, that the Constitution has always to be respected. And when the Constitution gives a role to a certain person, that person can't willy-nilly farm out the role to somebody else. And that was a very different case in nature from the first case.
Yes.
Where the court allowed the recount process to go forward pursuant to the agreement between the leaders of CARICOM. And I agree that courts are very important institutions, but sometimes courts get it wrong. I mean, no lesser institution than the United States Supreme Court gave us the Dred Scott case.
Exactly.
They also gave us Plessy versus Ferguson, saying that, Black people are not entitled to be citizens of the United States and that separate but equal is constitutional. We could not at that stage decide we're not going to be bothered with the courts anymore. Because later on down the road, the court gave us Brown versus Board of Education.
Board of Education.
So occasionally the courts get it wrong. And unfortunately, the people who are in the present when the courts get it wrong, they suffer the consequences. But history very frequently vindicates them. So it is important that even where confidence in the court may waver, that we do not abandon the court as an institution, and we do not go around giving the impression that proceeding to the court is a waste of time, because there is no other guardian of the Constitution in our system than the court. And if we are serious about protecting the constitutional rights of all the people on whose behalf we advocate, then we have to make sure we stay with the court and go back to them time and time again. Give them an opportunity to address past wrongs.
Thank you very much, Mayo. Robertson, before I go to Roysdale to give an update on, you already gave us an update on the petitions, and asked Roysdale to give us an update on the case for the natural resource. But I want to make two observations. The court said to GCOM, you have latitude. And then when GCOM overstepped that latitude, the court said, but you overstep, you can't bring in CARICOM to run your story. So the court is finding itself here. GCOM, you have the latitude to decide the procedure. GCOM goes ahead and call in CARICOM and say, we outsource the thing. And then the court said, no, GCOM, you're wrong. I think that's 5 months. As a student, I'm not a lawyer. As a student of the law, certainly the collision of law and politics, I find that 5 months fascinating. I really don't, and that's why I've not gotten into all the story about rigged elections and all that kind of stuff. I think it's fascinating. Generations to come and look back at that 5 months and see it as a defining moment in Guyanese jurisprudence. Go ahead. Go ahead, Mayo. You were saying something?
No, I finished what I was saying.
Oh, okay. Yeah. Roysdale, you filed that case on the NRF, I think a week ago. Give us a sense of, first of all, people said you all filed it a little bit too late, but let's not argue over that. Because sometimes you have to do your preparations, take your time, and so on. But tell us a little bit about the larger perspective from which you decided to file that case.
Dr. First, I want to deal with the issue of the perceived delay in filing the matter. It is part of what you discussed earlier, Dr. Hines. Part of the fact that some persons will be saying that the court is a waste of time. And then you proceed and you file a matter. You didn't file the matter as fast enough as you could. You see, part of the public awareness process that I believe that shows like this play, and I'm always happy to come on your show, because I believe it offers an opportunity and an insight into the work, for example, that I would do as the Shadow Attorney General, or Mayo would do as part of a team engaging in these sort of significant matters. To the general public, it may be you just put some papers together and you run off by Crow Street there, drop it in the court, and it's magic when eventually result in a favorable outcome. It's not magic. I recall Mr. McKay, my mentor and person who provided me with tutelage during my early period as a lawyer, always saying that good law is not instant coffee. Right? It's not something you just mix up and drink. The preparation for this matter required significant hours of research, not only by lawyers in Guyana, but in Africa, in Trinidad and Tobago, in Canada and other parts of the world, because the case dealt with a number of important issues which were never previously extensively discussed by judges or jurists, and never at once at all deliberated by our courts and even courts in the Caribbean. It deals with really and truly what is the nature of Parliament and under what principles it would govern. The night in question, not getting into the circumstances of what transpired that night, but a number of important things occurred. The first was that it was an undisputable fact that the mace was not in the house at the time. It's not disputed that the proceedings went beyond the time defined by Parliament for which laws could be passed without a formal extension. So the case deals with those issues and seeks to raise the issues for determination. as to whether the National Assembly can sit and function without the mace. Now, we will say, want to say that the mace is just a little device, it's just a little piece of metal, and you could therefore act and operate without it. But it is very interesting to note that the speaker himself found that there was such an important need for a mace that he produced a mace, which itself, he says, was a lawful mace, and he used it, in his opinion, to complete the proceedings that night. So before that night, by the way, Dr. Hines and members of the public listening, we were never aware that there ever existed any other mace. So you might think on one hand, the mace is a waste. Who cares about a mace? It's just a big thing there that's put in front of the speaker. But when it wasn't there, the speaker whipped out one, which in itself, and in his subsequent statements that he made on the 30th, the next day, he said that the mace was necessary to give legality to the parliament and to the parliamentary proceedings. So the fact that he produced one, I believe, supports and raised the issues as not being far-fetched for consideration as to what is the importance of this mace and why we need to have it in parliament. And the fact that he produced one out of thin air, I would suppose, unknown to anybody else, it brings us back to the question where we started off from on judicial review, whether it is within the power of one man to suddenly keep such an important legislative instrument somewhere lurking in his back pocket and pull it out and put it on the table and say, this is it. Um, these are very important issues. It goes towards the control of Parliament. It goes towards the management of Parliament. It goes towards Parliament executing its legislative functions. So the case deals with those issues. But more importantly, Dr. Hines, I believe that that day, the 29th of December, and the Guyanese people don't engage, I believe, in sufficient writing, and I might myself be guilty of the crime that I'm referring to. But on the 29th itself, it's a very important day in the life of the nation of Guyana. Because, you know, Dr. Hanks, and I'll send it to you tomorrow for you to have a read of the Hansard of that day. And it's somehow indicated from the beginning of that proceeding, that sitting that morning, that it was not going to be a normal day. Um, the speaker announced very early that morning that he had received a petition submitted to him by a member of the parliament on behalf of at least 64 citizens who were complaining that they had insufficient time, to consider the natural resource fund, that they had insufficient time to consider the impact and purport of the natural resource fund bill, and they wanted to have an opportunity to present their concerns to the National Assembly. The speaker said, and I'm going to paraphrase him here, I have it written down, but I'm going to paraphrase him here. He said that he had received it a few moments ago and that he will have to consider this at some future time. Now, on one hand, Dr. Hines, at least 4 months have expired, and the speaker has never referred to the issue of this petition ever again, because it has become spent and irrelevant, because the speaker permitted the Natural Resource Fund to come into law, to be passed, by the National Assembly. It was enacted by the president and assented to in the dark of the night, early in the wee hours of the 30th of December, and brought into effect as law. So what the case deals with, Mr. Dr. Hines, and for Mayo, I'm bringing him up to speed, even though we discussed it to some extent. The case deals with what is the role of civil society and what is the role of citizens as it relates to the National Assembly, as it relates to the execution or enactment of laws that impact upon their lives, that impact upon their well-being, that impact upon their children and their grandchildren. And there was no more an important issue
to bring these issues before the court than the Natural Resource Fund, a bill which was supposed to, or an issue which dealt with the nation as a whole, its well-being. It dealt with intergenerational wealth, it dealt with savings, and at the same time, for those of us who happen to be alive at this time, it offers the prospects for an improvement in the quality of our lives and for our families. And I believe that is a sort of issue that should have transcended narrow partisanship. And this is a natural resource for the entire country. And I believe that this is some way beyond the power of the PPP and the majoritarian instincts as represented in the National Assembly, for them to somehow believe that they could unilaterally decide the issue of the spending, what it is spent on, how it is spent, of the Natural Resource Fund for the entire citizenry of this country. So the fact that the Speaker decided to go ahead, the fact that there was absolutely no consultation, we had the Stabrook News issuing editorials, we had Kaito News issuing editorials, we had the Chamber of Commerce's complaining that this bill must be not proceeded with. You had the trade union movement, you had Article 13, a civil society organization, you had the Policy Forum Guyana group, all complaining that their rights to consultation, their rights to participation, their right to impact upon the type of law and the type of measures that will be brought into effect through this law was completely disregarded by Parliament and by the National Assembly. So I believe, Dr. Hines, that this is a very important legislation that was being brought, and therefore we had to respond to it with caution. We had to respond to it with a certain degree of confidence at the same time whilst executing our research. I believe that this case, Dr. Hines, will somehow have a serious impact on the way in which the polity of Guyana as a whole, how this republic functions going forward. I believe that we put things in law and we somehow put it there and it is left lying down on pages. And it is time that the Guyanese people, and I believe lawyers, have a special role to play in this society and in societies generally, in the advancement of rights of people, in advancing the type of society that we live in for the better. You know, Dr. Hines, during the last constitutional reform process that this country engaged in, it put into the Constitution Article 154 of the Constitution. I've had it somewhere. Article 154 of the Constitution. Article 154 of the Constitution, Dr. Hines, is a provision, 154A to be more precise, is a provision in the Constitution which basically incorporates international law, that incorporates in the fourth schedule to the Constitution, it incorporates a number of different conventions. And one of the conventions that it incorporates is the International Covenant on Civil and Political Rights. And it may sound very far-fetched and so on to the Guyanese people, but these are rights that are lying in the Constitution which have not yet been explored. And this case seeks to raise before the court for exploration and elucidation the issue of the right of citizens to be involved by way of organizations, by way of themselves, in public participation, public consultation, in decisions that affect them. Now, we have in our Constitution, in Article 13, that civil society must play a role in governance, in inclusionary democracy. But since 1980, I believe that provision existed. We have had no meaningful development in that vein by no government in terms of institutionalizing it. We had the advancement in the early 2000 period where these rights were now put into the Constitution in Article 154A, and we have had no litigation on it in terms of what this means and how it actually impacts on the lives of the ordinary people. Because, you know, it says in same Article 154A that the court, the judiciary, the executive, and the legislature, that they are bound to give respect and to uphold these rights. That therefore, we we contend, Dr. Hines, that in Article 154A and by extension its incorporation of these international covenants, that they include the right of the Guyanese people to be consulted in areas that affect them, in laws that will be passed. So I see this case as fitting into the long perpetual struggle for social justice. I believe that social justice must be defined as the continuous quest for equality, for the continuous quest for greater participation in civil society in terms of governance, the greater consultation in terms of decision. I believe that it would play an important role in advancing the concept of the rule of law and ultimately in the creation of policies that impact on people's lives. So I believe that this case will have a material impact on how Parliament functions in the future. Is our Parliament simply to sit there and pass laws, whatever they wish to pass laws on, and the Guyanese people are there just like sheep, not to say nothing much. That somehow by an election, whether we want to consider it a fraudulent election or a legitimate election, is it just by an election that the Guyanese people would have ceded their rights by a cast of a ballot um, to a group in Parliament, whatever the group may be, numbering 33, who could basically pass any law, even though it's not unconstitutional, that will not that will simply affect their rights, and they're just left in their homes and their communities to whimper and murmur. I believe that our constitution does not want that sort of compliant sheep-like um, population and citizenry. And therefore, that is why embedded in the pages of the Constitution are these rights. But as you said earlier, Dr. Hines and Mayo mentioned it, we have to wake up the Constitution. We have to make these pages come alive in terms of rights and responsibilities of citizens and of the government at large.
Yes. Lawrence Houston is pointing out that Article 15 also speaks to economic rights to be protected and to be affected. And I'm so glad you made those last points there, Roysdale, because I've been thinking about the concepts of implied powers and enumerated powers and so forth. I'm so ashamed of myself sometimes that I know the American Constitution a little bit more than I know our own Guyana Constitution. And I wanted to ask you lawyers this question: do you think our Constitution suffers from not having more enumerated powers, especially in a society like ours? And so it's left all the time for one to imply what the framers meant. What do they mean in Article 13? What do they mean in Article 15? What do they mean in Article 154? Mayo, you want to take a crack at that first?
Yeah, I believe a very good argument could be made for saying some of these powers should be enumerated. And Roysdale gave an excellent exposition on why it is important that this case was brought at the time it was. When I was on the program the last time, David, you had asked me a couple of things. You had asked me about whether I thought the law could be challenged based on the absence of the mace. And at the time, I had said that I don't believe the courts would be inclined to look into the inner workings of Parliament. And I still sort of hold that view. But I also said that a good constitutional lawyer could make a very good argument that this law was not in keeping with Parliament's duty to pass laws for good governance for the people of Guyana, especially since you're taking away the property of countless generations of unborn Guyanese. We're dealing here with a non-renewable natural resource. And those of us who live in 2022 are no more entitled to it than those people who are going to be living in 2122 or 2222. So especially because this is a natural resource, we have to try to make sure that all those implied powers in the Constitution, and some are in fact expressed but not detailed. And Article 154 that Roysdale referred to, for instance, is a perfect example. It's expressed, but it's not detailed. So it is more easily ignored. So to answer your question more directly, yes, perhaps it makes sense to enumerate some of these things. But at the same time, we don't want to be caught in a situation where we say, since it was not enumerated, it is not a right that can be available. Because we are developing democracy, and we must give ourselves the room to let our Constitution reflect the changes in our dynamic society. And so I guess like a typical lawyer, I'm saying yes and no. But
yes.
I think Roysdale has done an excellent job.
Yeah, and I do. And I want to make a distinction here, Mayo, between a typical lawyer and a legal scholar, because I think they're two different. You can be a lawyer, but not a student of the law or a legal scholar. And I think, in fairness to our audience here tonight, who are really absorbing a lot of this, what we're dealing with is the law as more than just dispute resolution, but the law as an idea about how you build a society, how you build a particular society, and the role of the law in that. And I think I always see whatever I do in the public sphere always contending with ideas, because I think, we have gotten to where we have gotten because we have developed ideas of how to break down walls that have, and we have turned those ideas into action, and we have generated ideas out of that action and keep our society propelling over the period of time. Royce, then I put the same question to you about enumerated powers.
I believe that we should be enumerated. But Dr. Hines, when you look at countries like South Africa and what they have gone through, and then you look at the Republic of India and the type of judges that they have produced, the judges have many times stood at the forefront of preserving the society as a whole. And they do this by not only being aware of what the law says, but they're aware of the history of injustices in the society. So we need to have judges who will understand that they're not just there to read pieces of paper and to construe the words or what the words mean on the paper, but to understand historical injustices, to understand acts of oppression, to understand discrimination in its manifest ways and multiple ways that it can happen. For example, our friend and viewer there, Lawrence, mentioned the issue of economic rights. Now, Dr. Hines, those things appear in part of the Constitution, which says that they are not to be given any effect. Article 13 appears in that category.
Mm-hmm.
But when you look at what the Indian judges would have done, they would be able to link those sort of rights to substantive rights that appear in other areas in the Constitution and say, no. A right to life means that a man must be able to get a proper salary. A right to life means that a man must be able to get a proper job. A right to life means that a child must be able to have access to education and housing. And when you look at the cases that evolve from places like South Africa, they're rapidly developing their laws to recognize these sort of social and political and economic rights. And they've been putting standards in place in terms of the government must comply with in their budgetary allocations. So, Dr. Hines, for me, being a member of parliament and being a member of the People's National Congress Reform, coupled with the fact that we have to deal with the law, for me, it would make no sense to say that the court is an area that we must not tread on. I believe that we must utilize our intellect. We must broaden the battlefield in this battle for a better Guyana. And that is the only way in which it could be done. Because when you look at what is happening in society, the government needs to be confronted in every way. And we need to confront them in new and creative ways. We need to follow the trends that are emerging in the world today and fight them, recognizing those trends.
Thank you. Rapid response here. What's new about what the head of the Bar Association has said, that the system for selecting the Chief Justice and the attorney, the Chief Justice and the Chancellor of the Judiciary has not worked? Anything new there and or taken? Starting with you, Mayo. Mayo is there with us? While we wait on Mayo, Roysdale, you can go.
It's nothing new. You're well aware since 5 or 6 that we have a confirmed Chief Justice. We had not have a confirmed Chancellor. Whilst I understand the need to have a confirmed Chancellor and a confirmed Chief Justice, and I support it, not just as a lawyer, but as a citizen of this country, and the importance that the judiciary plays in our society, I do not agree that necessarily we must just simply change the system. I observed that the President of the Bar Association did not articulate what is the alternative to the current system that we had before. The current system seeks to have consensus. And I believe that that is the sort of model that we need to support in the society. You know, a few years ago, I believe it was in the decision dealing with the appointment of the chairman of the Elections Commission, the CCJ underscored the need to have consensus. They underscored the need to have consensus as an underpinning, as a pillar of our Constitution. So I believe that if the alternative is to go back to the sort of independence type provision where just after consultation with the leader of the opposition, a blasé process, we would have a Chancellor and Chief Justice, I will oppose any such amendment to the Constitution which removes the need for consensus. What I believe we need to have is some mechanism that will support the consensus, that will drive the process, that will make it limited by time, so you can't go on forever.
Right.
And we could build around it rather than removing that process. The reason why I'm concerned about this, because I see more and more, Dr. Hines, the mindset, the trend of this current administration to reject anything that may appear to be based on consensus, to reject the need for consultation, to reject the need for participation. And it's a very dangerous process. I don't know how many of the citizens are paying attention to it. You have the president, Irfan Ali, saying that he will not consult or seek to have any consultation with the leader of the opposition on any matter until the leader of the opposition recognizes that he's the legitimate president. We see the fact that they sought to ensure that the most appropriate time to engage in the appointment of a commissioner of police is when the last leader of the opposition resigned and we during the period of waiting the appointment or the elections, I should say, of our current leader of the opposition. We see the fact that they want to engage in a process of removing an entire police service commission. For the past 2 years, they've not engaged in any process that will lead to the appointment of a judicial service commission, a police service commission, teaching service commission, ethnic service commission, the ethnic relations commission. The public procurement commission was languishing for a long time, and a number of other similar bodies under the constitution are simply left to the sides because they don't want to engage in consultation. And could you imagine, Dr. Hines, and a sitting attorney general saying to the public that his government don't need to consult with anybody. They don't need to consult with anybody. They could pass whatever they want to pass because simply they have 33 seats in parliament.
Yeah.
That is the sort of frame in which we currently operate in. This is the frame in which the Guyanese people have to live. It is so bizarre and nonsensical to believe that you could be actually sitting as the Attorney General of this country, a country that on the face of it, Dr. Hines, on the face of it, you could just land from Mars and pop in, and you could see the divisions in almost every single aspect of the society. Those who live on the coast, who live on which part of the coast, who live in what village, who vote for who, where you work, where you live, and you don't have to consult with anybody. And that is the danger of the current administration in this society. They will continue to aggravate problems that will lead to social unrest, potentially. They will lead to continuous alienation of people from society, and we will not have any meaningful development. That is why you could ask the youngest child in this country today, Dr. Hines, the whole concept of a one Guyana is a joke and something that ought to be so sacrosanct as a one Guyana policy. Everybody regards it as a joke. It has no substance to it. It has no ring of truth and has no ring of sincerity to it.
Yes, thank you. Here comes. You want to respond to that question there, Mayo, on the question of whether, in fact, the head of the Bar Association is leading us to anything progressive?
Well, I agree with what Roysdale is saying. The truth is the system has not worked because we have not had a confirmed chancellor, I believe, in the last 15 years. That's very long. But the answer is not to abandon the objective of cooperation, not to abandon the objective of government needing to consult with the opposition. I mean, the reality is, for the past few years, successive governments in this country have been ruling by the slimmest of majorities. And they must understand that if they really want to govern for all of Guyana, you have to consult. So while the system has led to gridlock in terms of the appointment of the Chancellor and the Chief Justice, the answer would be a whole lot worse if we were to say, give the government the power without the need for consultation, without the need for negotiation. So we must not abandon the pursuit of the goal of consultation just so we can have a permanent appointment, because it will do more harm than good. And if anything, it could erode confidence in the court. And as Roysdale and I have been saying, we don't want to do anything that would destroy the institution of our judiciary.
Thank you so much. Brother Coffee, I see your question. Norman Brown, I see your questions. But I wanted to get in so much from our guests. I will engage them in the not too distant future to come back and to take some questions from, because some of your questions are really interesting, but you would appreciate that the time doesn't permit us to get in those questions. But I have taken note of them, and I will ask our guests to come back. It'll be short on discussion and more on answering your questions, and I'll try to schedule that as early as I can. I want to thank all of you all for very interesting insights. I see my first boss when I came to America about 40 years ago, Ulrich Patterson, is on tonight. Hi, Rick. Good night, and hope all is going well. Gentlemen, let's have some quick closing thoughts from you, starting with Roysdale, and then you'll close us off, Mayo.
I just want to assure the Guyanese people that whilst we would disagree with decisions delivered by the courts, and we have every right to, that we must remain confident that the court provides an opportunity, it provides the resources and the power the court possesses under the Constitution to be a guardian of our rights. I believe that we will have to continue coming to court. We have to continue presenting our arguments in the public domain for them, for citizens to understand what it is that is coming up against them. And I believe that we will continue to do so. Thank you, Dr. Helms.
Thank you so much, Roysdale, for coming on. And Mayo, your closing thoughts?
If I may focus a little bit again on the National Resource Fund, I think it's important that the public get engaged in it because, as I said, it is something that affects not only us, but it's something that affects the property rights of our children, our grandchildren, our great-grandchildren, and so on down the road. And on another less serious note, David, I hope I'm not appearing to be disrespectful because Roysdale keeps referring to you as Dr. Hines, and I keep saying David, but you and I are the same generation. We go back. So please understand, no disrespect is intended when I say David.
That's all right, Mayo. I refer to you as Mayo. We go back in Washington, D.C. way back 40 odd years. Ulrich Patterson is from Washington, D.C., Maryland. They would know you. That's quite all right. Thank you, Mayo, and thank you, Roysdale, for coming on. I can assure you, this is a primary tonight, as some people say a primer, but I so wanted to do this show because of the feedback you get every day. And you kind of figure out there's some questions that need to be answered. That's the reason I approach you all at this particular time to come on and do the show. And I think you all have enriched our discussion. I keep saying to our audiences all the time, we have to fight on all fronts. We have to equip ourselves with knowledge and idea because we're up against not a bunch of individuals. We're up against an idea of what Guyana should be from those people's standpoint. And they're pursuing it with every twist and turn. And they have their people doing their research. They're researching our very shows that we do. And we must not give up any inch, not an inch of the arena of struggle. And most of all, we hear how people say all the time that talk, and no action. We must not give up talk. The minute we go silent, we become dead, and the other side wants that. Thank you, my brothers, and thank you, the audience, for buying in to the practice of this show, which is not to entertain, but to entertain knowledge and analysis as weapons of struggle. There are going to be nights when we're going to abuse out. There are going to be nights when we're going to wring terror air off from our head. And then there are going to be nights when we get down to the business of tearing the skin off and getting beneath the surface. Beneath the surface. Good night. Tomorrow night, we're on with the Henry Rodney tribute. Tomorrow night, Friday night, please put it on your calendar. There you go, tomorrow night at 6:30. See you then tomorrow night.
Please help keep Politics 101 on social media and broadcast television. If you are in North America, please donate via Cash App or PayPal.
If you are in Guyana and the Caribbean and don't have access to Cash App and PayPal, email your pledge to dhines6106@aol.com and we will direct you how to get your donation to us. Thank you in advance for your donation.